Hi, I'm Abigail Reynolds, an admitted attorney in South Africa. I want to talk to you today on behalf of Carrick Consult about the importance of having an independent trustee on your trusts. I'm going to be referring here to inter vivos trusts, which are trusts set up during the lifetime of the founder. So I'm not talking about testamentary trusts, which are set up under somebody's will. And I'm also talking about trusts that were set up before March of 2017, because at that time there was no obligation to have an independent trustee on an inter vivos trust. Many of us have family trusts that were formed many years ago and even generations ago, and these are the trusts I'm addressing in this podcast. What's incredibly important is for the trustees of the trust to manage it so that it is clear to SARS that the trust assets are not being managed by one or two of the trustees as if those assets belong to them personally. If SARS thinks this is the case, it can tax all the assets in the trust as if they were the personal assets of that particular beneficiary. And there's also a massive risk in divorce cases where one spouse can prove to the court that the other spouse actually used the assets in a trust as if they were his or her own. The court can then declare that some or all of those assets form part of his or her personal assets and are included in the division of assets on divorce. And that same process applies under insolvency cases, where a creditor can get a court to take assets out of a trust that has been managed personally for the benefit of one beneficiary and use those assets to part satisfy a debt owed by that beneficiary debtor. So what's important to show is that the trust is managed such that there's a real separation of ownership and control of the trust assets, which must be done by the trustees, and the enjoyment of assets, which is obviously done by the beneficiaries. So if the trust has an independent trustee, it serves as one way to prove that trust is being properly and objectively managed, and with the interests of all the beneficiaries in mind, according to the trust deed. And that's one reason why the independent trustee is not allowed to be a family relation to any of the beneficiaries or the other trustees or the founder, so that they can serve their purpose objectively. They don't have to have any special qualification, but they must have experience in managing trusts, and they must know about the fiduciary duties that fall on all trustees' shoulders. For newly registered family business trusts, the Chief Master's Office directive that was published in March of 2017 that I talked about earlier instructed the Master to consider appointing an independent trustee on these newly registered trusts and gave the Master the power to declare the whole trust structure invalid or void, and the assets would then be deemed to form part of the founder's estate. So you can imagine the unplanned impact of that. So this directive should give warning to the older trusts that are in place, that perhaps a directive could be issued that requires an independent trustee for such older trusts, and also to understand that it would be beneficial to have an objective independent trustee on the Board of Trustees so that we can carry on convincing the courts and SARS that our trust really is an entity separate from us as the beneficiaries. So all trustees are jointly and severally liable and can be held accountable for acting negligently or intentionally wrongfully, but the trust can take out insurance to protect the trustees against some of those risks, much like directors' insurance for a company. And in the case of professional independent trustees, it would often be that they already have such insurance in place. So let us know if you want us to review your trust deeds to see if and how an independent trustee can be elected, and perhaps to amend it to require that there always is one in place going forward, and also talk to us if you want an independent trustee, and Carrick Consult can advise. Thanks so much.